Greetings to each and everyone. Welcome to today's program, the International Family Law Year in Review, sponsored by the International Section and the Family Law Section of the New York State Bar Association. The program will run for an hour and 30 minutes, and participants are welcome to ask questions using the Q&A function in your Zoom portal. Note that this program does not carry any CLE credit. So without further ado, help me welcome our first speaker for today from MK Family Law in Washington, D.C., Melissa Kaczynski. Melissa?
Thank you. I'm going to put up my PowerPoint now. I have to have you take down yours though first. There we go.
There you go.
There we go. Okay. Um, I know people continue to move into the attendance and the queue as we go through. James speaks second, so you will not miss him if you're a little late. So welcome to our annual year in review webinar. It's now our seventh consecutive year, hard to believe, where James Netto and I are going to share the top international family updates from 2025 from the US and UK. I'm going to begin today. I'm going to provide the US updates for about 40 minutes, at which time I'm going to turn it over to James. He's going to then share his updates. It's a very full hour and a half. We're really grateful for your patience as we get through the material. We will provide our slides to the New York State Bar. They will be circulated to anyone who is registered, along with a recording of today's webinar. We're sorry, we probably won't have time for questions. So if you do use that Q&A, we may not review it and we may not have time to answer the questions. But you will get the slides, you'll get the recording. So hopefully everything will be answered. So today's first update is from the Hague Conference on Private International Law. Its governing body is the Council on General Affairs and Policy, which is abbreviated CGAP. It meets each March. It's the body of the Hague Conference in charge of directing the organization's work, including its approval of its future projects. The 2025 meeting was held in March 4th through the 7th. Its 2026 meeting will be held March 3rd through the 6th. So during last year's CGAP, the conference received a progress report from the chair of the Parentage Surrogacy Working Group. It's already produced a 2026 report for the CGAP meeting in March. It's already posted to the Hague Conference's website at hcch.net. The working group's most recent report includes draft language for a possible future convention on the recognition of judgments on legal parentage. It also includes an assessment of whether a future convention is even feasible. It lists certain areas where it may be impossible to achieve consensus among the states, including legal parentage in circumstances of surrogacy. So please refer to the Hague Conference's website to review the full report prior to CGAP in March of this year. In early of April of 2025, the Hague Conference, the IAFL, and the Canadian government hosted a several-day meeting in Washington, D.C. to discuss the Washington Declaration. The Washington Declaration is a several-page document putting forth considerations for resolving international child relocation disputes. The meeting was the precursor to some additional work, which was authorized by the 8th Special Commission of the Hague Conference held in October 2023. That extra work is for the Hague Conference to draft and distribute a questionnaire to states about child relocation. Speakers at the April 2025 meeting also published articles in the Hague Conference's Judges newsletter found on their website. In October of 2025, the Hague Conference hosted a second meeting on domestic violence and the Abduction Convention in Fortaleza, Brazil. The Hague Conference is working on scheduling a special commission for the Child Support Convention in 2027. It's also announced plans to hold a sixth Malta conference in April of 2027. As a reminder, the Malta process serves as a way for dialogue and collaborations between contracting states of the children's treaties and non-contracting Sharia states. Moving to the United States, the U.S. Department of State issues its yearly compliance report as mandated by Congress. It includes statistics on all outstanding child abduction cases from the US to other countries, and it explores some of the reasons why certain cases remain unresolved. The report includes both countries where there is a treaty relationship with the US under the Hague Abduction Convention and countries where there is none. The report looks at statistics for the year prior to its release. It specifically calls out countries that are non-compliant, and non-compliance is defined under the International Child Abduction Prevention and Return Act, which is ICAPRA or the Goldman Act for short. That's the federal law that actually mandates this report. For 2025, the non-compliant countries actually remain generally the same as for 2024, except that Montenegro and Russia were removed from last year's list, and the Bahamas was added as a non-compliant country to last year's list. The compliance report is found at travel.state.gov, so you can look for it there. Also, the U.S. Department of Justice Office of International Judicial Assistance, which serves as the U.S. Central Authority for the Hague Service Convention, on September 16th of last year, the OIJA distributed a two-page letter that clarified service of process issues that have long created confusion, at least for the US. The typical way to request that US court paperwork be served on a defendant in a convention partner country is to complete the Hague Service Form found on hcch.net and transmit it to the foreign country's central authority. There has been at times some confusion as to who in the US can sign and transmit that form. The OIJA letter reminds all of us that it's the requesting state, and in this case, the US, if that's where the paperwork was filed in court, that determines who is competent to transmit the form. And in the US, judicial officers can complete the form and transmit it. And the letter makes clear that lawyers licensed in a U.S. state are judicial officers. So lawyers can transmit this form to the Foreign Central Authority, and hopefully that will help some foreign central authorities when they're questioning who signed this form that they received for service of process. An exciting development from the Uniform Law Commission in July of 2025, the ULC approved the Uniform Judicial Interview of Children Act, which puts forth criteria for judges to use in deciding when and how to conduct an in-camera or in-chambers interview of a child in private proceedings. That includes international custody, relocation, and abduction cases. And it also is where other law requires that the child's views be considered. This act is now up for enactment by state legislatures. There is also a relatively new study committee on international litigation procedures that's exploring whether there may be room for one or more uniform acts on a variety of topics. That ranges from notice of intent to rely on foreign law in state courts, evidence and service issues, applicable law issues, forum nonconvenience, and some other private international law concerns. So stay tuned for the work of that committee. Now, turning to cases and starting with the Hague Abduction Convention, um, James will probably smirk when I mention this case because I believe it may have been his case. A recent case in the Indiana state courts, Winchester v. Winchester, and I'm sure he'll tell me all the things that the U.S. court said that were wrong, demonstrates a few procedural issues that should be front of mind for U.S. and at least the practitioners of England and Wales. This is another case of a U.S. military Air Force family. They relocated to the United Kingdom for a parent's, the father's military service. After some accusations of domestic violence against the military parent, the U.S. Air Force approved the non-military parent's request for assistance to arrange for travel for her and the children to return to the U.S. So she and the children flew to Indiana and moved in with her parents. And on what was said to be the same day, the father then went to the courts in England and filed for custody. The English courts held what the U.S. court said was a without notice urgent hearing. That resulted in a court order, and the English court also said that it was the child's habitual residence, or the children's habitual residence. The father then took his English order. He then took it to the Indiana state courts. He filed to have it registered under the UCCJEA. And then separately, he filed an application for the children's return under the Hague Abduction Convention with the UK Central Authority. The Indiana trial court ordered the children returned under the Abduction Convention and registered the English order. But then the mother appealed. The Indiana Court of Appeals reversed and remanded. It concluded that the mother did not have sufficient notice in the English proceedings, so the Indiana court should never have registered the English court order. Not registered, not enforceable. Furthermore, the court should not have taken any action to return the child under the abduction convention because the father never filed a lawsuit under the convention. Under our implementing statute, our CARA, he had to file a lawsuit, not just an application with the central authority. So, sorry, James, if that was not the right client for you. um, the next case, a petitioner, in order to make a prima facie case to return their child under the abduction convention, must prove by a preponderance of the evidence that they had a right of custody to the child under the law of the habitual residence as of the date of the abduction. So, after hearing from several Turkish law experts, the U.S. District Court for the Eastern District of New York, in the case of Tatari versus Durst, concluded that a petitioner father did have a right of custody under Turkish law at the time the child brought the children from Turkey to New York. The parties had actually gone through an uncontested Turkish divorce a few years earlier, and in their divorce decree, the judge ordered that the mother would have sole custody and the father would have visitation, and that the terms of a divorce protocol, which the parents had agreed to, would be substantially adopted and incorporated into the court order. Among the terms that were incorporated were a veto for the father over the children relocating and joint decision making over their education and health care. So, after a debate over which translation of the divorce decree they were going to use, the district court concluded that the father had a ne exeat right and a de facto joint custody right over the education and health care, and that gave him a right of custody. The district court disagreed with the mother's arguments. She argued that the divorce protocol's terms were not legally binding and that Turkish law only provides for sole custody that was granted to her and that allowed her to relocate. The Second Circuit Court of Appeals affirmed the father's return order. One of the most argued exceptions, of course, is a grave risk of harm that children would be exposed to that upon their return under the Hague Abduction Convention. The U.S. Court of Appeals for the 11th Circuit in Basat v. Dana reversed and remanded an order that required two children be returned to Israel. The district court found that there was no grave risk that the children would be exposed to harm upon return. But on appeal, the respondent mother, instead of focusing on maybe Israel and what had been going on at the time, actually focused her arguments on past intimate partner violence between her and the father. The 11th Circuit looked at the testimony of the parties, the father's denial of the harm, and specific incidents that the mother elaborated on, and the children's in-camera testimony. It concluded that the district court failed to say that the mother and children were not credible, and the incidents described by the mother did constitute a grave risk of harm. So the petitioner father then, having lost at the 11th Circuit level, sought a rehearing. That was denied. He had argued that any alleged incidents occurred in the very distant past, and in the interim time, he actually cared for the children while the mother was traveling. Unfortunately, that's where they stand. It remains to be seen whether or not he may petition for a writ of cert to the Supreme Court. On September 18th of last year, in the case of Aber v. Post, the U.S. District Court for the Western District of Wisconsin reached a conclusion about a petitioning father's rights of custody to his two children. It was a quirk in Norwegian law that relates to parentage based on where a child was residing at the time of their birth when the parents are unmarried. Because of that, the father only had a right of custody to one of his two children, and this meant that only one fell under the abduction convention and would be eligible to be returned to Norway. So during the trial, both parents did apparently admit that separating the children would harm them, and relying on that, the district court concluded that neither child should be returned because separating them would be a grave risk of harm. The father's appealed. I think it's going to argument at the end of next week in the Seventh Circuit. In the meantime, he requested the district court put in place an access schedule. He asked for one that would mirror what was happening during the pendency of the trial, but the district court denied his request, saying it had no jurisdiction to do that. A left-behind parent who fails to file a lawsuit in the U.S. for the return of their child within 1 year of the child's abduction and it becoming wrongful, they open themselves up to an additional argument against the child being returned. And that argument is that the child is now settled in the United States. So there was an interesting case out of the Fifth Circuit this past year. The district court, the trial court, found that a child had been settled in Texas and declined to return the child to Venezuela. But then the case was appealed, and at the Fifth Circuit, they disagreed and reversed. In their opinion, both originally and then they actually granted a rehearing and amended the opinion, but with the same result. The Fifth Circuit looked at various factors that have traditionally been set forth by case law about child settlement in these cases. In doing so, it just reached the complete opposite conclusion. It concluded that this child could not possibly be settled, and primarily because of the gloss of the child's immigration status. The child and the mother were in the United States waiting for an outcome on their applications to seek asylum. The mother had a job, the child was age 7, child was doing well in school, child had friends and community activities, but the court still found the child was not settled. They found that the mother presented no evidence that her asylum claims were likely to succeed, and the Fifth Circuit cast doubt on whether the asylum claims were even viable because there was no grave risk of harm found by the court, equating those two things together. So the court did have some language in there that they were seeking an individualized, fact-specific inquiry into the child's immigration status and how that interacts and undermines other factors related to the child's settlement. They noted that the uncertainty surrounding the immigration status permeated every aspect of their life, rendering it fundamentally unstable. The mother filed a petition of writ of certiorari to the Supreme Court on December 4th. The father filed a waiver to respond January 7th, but a few days ago, the Supreme Court has asked that he submit a response by February 17th. So we'll find in a few weeks what he has to say. Clearly, if two parents can reach an amicable resolution about their child, that seems to be the best thing. Two parents in the case of Ballesteros versus Ruiz were engaged in litigation in the U.S. District Court for the Northern District of Illinois on whether or not to return their child from Illinois to Canada. The family had been living in Canada but were originally from Venezuela and were seeking refugee status in Canada when the mother removed the child from Canada and brought the child to Illinois. The parties were ordered to go before a magistrate judge for a settlement conference, something that is becoming quite common in these cases in the US. At some point, the parties, through their lawyers, confirmed to the magistrate judge that they had settled the case and that they were going to file something with the court so it could be dismissed. But after 2 weeks, nothing had been filed, so the mother asked to enforce the verbal settlement that they reached in the conference. The petitioner father's lawyer conceded that they had reached an agreement, but he was arguing that there have been significant policy changes in the United States towards undocumented immigrants, and now he was scared that he wouldn't be able to actually enter the United States to visit his child. The district court held a hearing. They applied state law, Illinois, the law of Illinois, and concluded that there was a binding and enforceable settlement agreement and that they could enforce it, but they could do nothing more than enforce it because they don't have jurisdiction over the child's custody in the federal court. Quite a few U.S. states have child abduction prevention legislation. The legislation typically includes factors for judges to figure out whether there's a credible risk of abduction. And the Uniform Law Commission is actually the proponent of the 2006 Child Abduction Prevention Act, which is now enacted in 21 states. Some states like California and Texas already had their abduction prevention statutes prior to 2006. So in this first case, which was Texas, Hale versus Hale, which was January of last year, the Court of Appeals of Texas actually reversed a trial court who had put in place abduction prevention measures because the trial court had actually made no findings as to whether there was an actual risk of abduction. The mother was born in Russia. She moved to the US, married the father, bought a house, had a child with him, and after 10 years of marriage, they actually both sued for divorce in Texas. The father alleged that he was concerned the mother would abduct their child. And so the trial court put in place a lot of measures, limiting her travel to certain countries, requiring a bond before travel to Russia, things of that nature. But the Court of Appeals made absolutely clear that the first step is that you actually have to make a finding that there's a credible risk of abduction. Because a trial court had not done that, then they reversed the abduction prevention measures. And compare that to In Re Marriage of Wang, which was a March 2025 Iowa case. The Court of Appeals of Iowa affirmed certain abduction prevention measures. Specifically, the trial court had required the father who resides in China to only have visitation with the child in the United States. The trial court had actually they adequately weighed the child's best interest. They coupled it with the fact that China is not a party to the Hague Abduction Convention. They looked at the father's past behavior where he'd actually prevented the child from leaving China at the end of a vacation. And therefore, the restriction on the father's visitation was supported by the record. Also, in a similar case in Florida, List versus Kaplan List, a father was concerned about the mother abducting their child to Russia. Both parties actually retained lawyers as experts for trial. Both lawyer experts testified as to whether they felt the mother presented a credible risk of abduction, which actually is the ultimate issue that the court needed to decide. The father's expert had never spoken with the mother. He based his entire opinion on comments made by the father. So the court concluded that the mother's expert was more credible. That expert acknowledged there's always a risk of abduction for multi-jurisdictional families, and they opined that the various factors that are part of Florida's version of UCAPA tilted in favor of the mother not being a risk. The judge put in place certain tailored measures related to the child's travel, but they didn't prevent travel. So this case is actually an interesting example of experts who are lawyers opining on a parent's behavior and whether they feel, despite only being lawyers, that a parent may engage in bad behavior, something more traditionally left to behavioral experts or to the judge. In February 2025, the U.S. Court of Appeals for the Eighth Circuit in U.S. versus Zelinsky affirmed a mother's criminal conviction for kidnapping her minor child from the U.S. to Mexico. This was prosecuted under International Parental Kidnapping Crime Act. That act has an affirmative defense against kidnapping that if the defendant was fleeing an incident or pattern of domestic violence, that was a defense to the kidnapping. In this case, the mother argued that she was fleeing domestic violence, but against the child, not against her. The district court and the majority in the Eighth Circuit concluded that that language only applied to domestic violence that was aimed at her, the defendant. They concluded that permitting a defendant to flee violence against a third party would have unintended consequences and turn every prosecution into a replay of the child custody proceedings. There was a dissent in the Eighth Circuit. They read the statute a bit differently, especially because of the intimate connection between parent and child. And it concluded that the defendant is still fleeing, even if it's against violence against their child. So the mother did file for a panel rehearing in March of last year. That was denied. In July, she filed a petition for writ of certiorari to the U.S. Supreme Court. In November, the U.S. government filed its reply brief and acknowledged that the defense should include fleeing violence against a child. So the mother then filed a reply arguing for a petition of writ of cert being granted and for the court to summarily reverse or grant plenary review. On January 12th, just a few days ago, the writ of cert was granted by the U.S. Supreme Court without argument, with an instruction to remand for further proceedings based on the Solicitor General's views. The Uniform Child Custody Jurisdiction and Enforcement Act is the exclusive means to determine child custody jurisdiction in states that have enacted it, which is every state but Massachusetts. The UCCJEA provides prioritized legal bases for establishing jurisdiction for an initial child custody order. It also treats foreign countries, but for in some rare circumstances, as equal to sister states within the U.S. The prioritized basis for an initial child custody jurisdiction is the child's home state. Home states where the child resided with a parent or a person acting as a parent for 6 months immediately preceding the filing of the lawsuit for custody, minus any temporary absences. Child custody is subject matter jurisdiction. That means it cannot be waived or consented to. In the case of In re Jenkins, the Court of Appeals of Texas addressed jurisdiction in a father's custody lawsuit. The child in this case was born in Japan, had lived his entire several-year life in Japan and was still residing in Japan on the date the father filed for divorce and custody in Texas. The father filed in Texas because it was his last residence prior to him and his wife being deployed to Japan for his U.S. military duties. When the mother fought jurisdiction over custody in Texas, the question is, of course, where's the child's home state? And under the facts here, it's Japan. However, the father argued that because the family was residing in Japan pursuant to a status of forces agreement, the Japanese courts had no jurisdiction to take up a custody case. He cited two paragraphs of the SOFA between the US and Japan to make his argument. Having read the language, the Court of Appeals was not persuaded that the Japanese courts would actually decline jurisdiction based on the SOFA. And so, being that Texas was not the child's home state, they dismissed the case, or the custody case at least. The Court of Appeals of California also addressed custody jurisdiction in CT versus Superior Court. The subject child was born in 2018. A custody case was filed in 2019. The case was still open with no final resolution in April 2024, when all of a sudden the father got a job opportunity in Denmark and asked for permission to relocate the child. The court granted his request on May 2nd of 2024, but made clear that it was not a final custody order. They also mandated interim therapeutic visitation and a custody evaluation. Shortly after the father relocated and the mother, who was presumably residing in Utah, the father sought California to determine that it no longer had subject matter jurisdiction under the UCCJEA. In other words, no one lived in California, so he wanted California to dismiss the case, which had been pending for the better part of 5 years. The trial court, however, said no, California was the home state at the time the custody proceeding was commenced, way back in 2019. The Court of Appeal agreed. It referred to the reporter's comments from the ULC to the UCCJEA that confirmed this. Now, note, if California had wanted to, it could have declined its jurisdiction in lieu of a more appropriate forum, i.e., Denmark, but that didn't seem to be argued or decided by the court here. The Court of Appeals of Indiana also addressed jurisdiction over a minor child in an international custody case, Guard Home versus Home. The child was born in Germany in July 2023. A few months later, the parties separated. The mother then met with a German legal aid attorney who filed for custody in the German courts. Within days of the lawsuit being filed, she then left Germany and traveled to Indiana on an emergency use passport with the child. A few weeks later, now it's December of 2023, she filed for custody in Indiana. In January of 2024, the German court held a hearing on the custody application. Her legal aid attorney showed up. She did not. The German court gave the father custody. In April of 2024, instead of filing a request under the Hague Abduction Convention, the father actually brought the German custody order to Indiana and sought to register and enforce it under the UCCJEA. The mother argued Germany has no jurisdiction of the case because the child was less than 6 months old, but the Court of Appeals of Indiana affirmed the trial court that said, no, the UCCJEA defines child's home state. For children under 6 months, it's where the child has lived from birth with a parent. The German courts had jurisdiction, not only under German law, but in a way that was substantially in conformance with the UCCJEA. And that was at the time that it was filed. So Indiana must register and enforce the German custody order. Custody jurisdictions pinned down at that time the commencement of the lawsuit. I mean, as a note, I think this was probably the correct analysis, but if Indiana had found jurisdiction, it could have declined based on the mother having unilaterally brought the child to Indiana. In O'Malley versus Izquierda, the Superior Court of Pennsylvania actually relied on some interesting evidence to determine it had jurisdiction to modify a prior Pennsylvania custody order. This child was born in Pennsylvania, and after about 8 months after the birth, the family all went to Brazil, which was to be a 1-month visit. But then the mother refused to return to the US. The father came back to Pennsylvania. He filed a lawsuit for custody. He got a custody order. He also pursued the child's return in Brazil under the Hague Abduction Convention, which ultimately was unsuccessful, in that the child is still not back in the United States. But the Brazilian courts issued orders, and in the orders, the Brazilian courts presumably said they had no jurisdiction over the child's custody. So the father then moved to New Jersey, and no one is now in Pennsylvania. It's years later. Child's still not back because the mother didn't bring the child back pursuant to the abduction convention. So he sought to modify the Pennsylvania order in Pennsylvania. No one's in Pennsylvania. The court had to examine whether it had jurisdiction to modify the order. And the mother and child, still being Brazil, father in New Jersey, they reached the conclusion that the Brazilian court orders from the Hague proceeding actually was Brazilian courts declining jurisdiction and concluding that Pennsylvania was a more appropriate forum. On that basis, that piece of evidence, the Pennsylvania courts decided to take up modification jurisdiction. They didn't want to reward the mother's actions, and they didn't want to leave a void of where the parents could pursue custody. The UCCJA requires direct judicial communication in certain circumstances between the state court judge and the judge of whatever other jurisdiction is proceeding. The requirement was on this requirement was on full display in an unpublished Wisconsin Court of Appeals decision, Vargas v. Nola. The Wisconsin court was asked to determine whether or not to cede its custody jurisdiction in Mexico. So the Wisconsin judge ultimately ended up seeking out a conference on Zoom with the Mexican judge. They set a date, a time. The Mexican judge didn't respond, but when the date and time arrived, the Mexican judge popped onto the Zoom. They had a translator. They had a court reporter. They had conversations. They talked about a variety of things, including the proceedings and service of process. Then they scheduled a second conference and discussed the conflicting accounts of where the parties had resided, appointing a guardian ad litem. The court in Wisconsin, kept the parties informed of the communication throughout. It allowed them to submit factual and legal arguments to both courts. And ultimately, Wisconsin dismissed the action and ceded their jurisdiction in Mexico. So on appeal, the mother argued a lack of opportunity to provide input and off-the-record discussions, but the Wisconsin Court of Appeals said no, they had more than sufficient opportunity to present their arguments, and what happened sufficed. In February 2025, in the matter of Penachet versus Ann Caroon, the Supreme Court of New Hampshire concluded that a New Hampshire father didn't have sufficient connections to Mexico to warrant enforcing a Mexican child support order over him in New Hampshire. The child was born in New York in 2016. They entered a New York stipulation, the parents, that permitted the mother to relocate anywhere in the world with the child, including her native Mexico. She did ultimately move to Mexico, and the father was residing in New Hampshire. She requested and obtained an ex parte temporary order of child support in the Mexican courts. She then brought it to New Hampshire to register and enforce. The New Hampshire trial court concluded that the father had insufficient contacts with Mexico to justify Mexico exercising personal jurisdiction over him, and therefore it refused to register and enforce. She appealed. The Supreme Court referred to New Hampshire's enactment of the Uniform Interstate Family Support Act. And the general premise of UIFSA is that New Hampshire will recognize and enforce foreign support orders so long as the issuing tribunal had jurisdiction in a way that was similar to that in UIFSA. There are 8 grounds enumerated in the long-arm provisions of UIFSA that would permit jurisdiction over a non-resident defendant. And after the hearing, the father actually met his burden to demonstrate that he had none of those personal contacts sufficient that Mexico should have issued a child support order over him, despite the child living in Mexico. The fact that he had agreed for the child to relocate anywhere, including Mexico, was not sufficient. So the mother can come and seek child support in New Hampshire. In February, in Cavalcanti, Lira versus King, a mother filed an application to establish child support with the Brazilian Central Authority that she and the child resided in Brazil. The father resided in Michigan, so the Michigan got the child support application. In the application, she noted that paternity was established or presumed. She attached a Brazilian birth certificate that named the father as a parent. The applicable Michigan agency filed for child support against the father, but he then sought to dismiss the suit and fight it on the fact that there was not a proper establishment of paternity. The mother kept arguing that because he was on the birth certificate in Brazil, that under Brazilian law that established paternity. But apparently her assertions, while they persuaded the trial court, did not persuade the Michigan Court of Appeals. The Michigan Court of Appeals concluded that her assertions alone did not establish paternity under Brazilian law, and that they should establish paternity prior to seeking a child support order. So they vacated the child support order that the Michigan trial court had entered. Another child support case, the Minnesota Court of Appeals in the case of a professional baseball player, Randy Jackson, concluded that it could enforce a Japanese child support order against him. He had been playing ball in Hiroshima and he had a romantic relationship that produced a son in Japan in 2018. There were various lawsuits in Japan. One, of course, was a child support lawsuit, which yielded a child support order. The mother then tracked him down to playing for the Minnesota Twins and filed to register the Japanese order in Minnesota. He contested the registration on personal jurisdiction grounds and by arguing that the order was not a quote unquote foreign support order under the Uniform Interstate Family Support Act. To be a foreign support order, Japan needs to be a foreign country. UIFSA defines foreign country as one of four different things. Of those four things, Japan is not one, a foreign reciprocating country. Two, there's no Minnesota-Japanese reciprocal agreement for child support. And three, Japan has not signed the Hague Child Support Convention. So that leaves the fourth option that Japan has enacted a law or established procedures for the issuance and enforcement of support orders that are substantially similar to those in UIFSA. Based on a Japanese lawyer's affidavit, the Minnesota courts concluded that Japanese law was substantially similar. As a quick note, it needs to be substantially similar. It does not need to be identical in terms of its law. So the order was enforceable in Minnesota. US-based retirement accounts. They're routinely divided at the time of divorce by way of a special court order. So for qualified retirement plans meeting the IRS and ERISA requirements in the United States, the court order is referred to as a qualified domestic relations order. US lawyers know these well. These orders are entered by US state family courts after a divorce is decreed. If the divorce, however, occurred overseas and the foreign divorce decree provided for the division of a US-based retirement, it will probably be necessary to seek recognition of the foreign divorce decree in the relevant US state court as a matter of comity, so that the court can then enter the proper US retirement order to divide the retirement account. So this is what happened in April of last year in DSS versus CB. A Swiss family court in Geneva had entered a marital settlement agreement that was presented to it by two spouses. It provided for a division of their assets, including the husband's retirement with Columbia University in New York. A New York court would have in rem jurisdiction over that asset. The parties cooperated in filing consent paperwork in the New York Supreme Court to seek recognition of the Swiss judgment and the enter of the retirement order. So my final slide of substance, in the case of Mula Omerovic versus Mula Omerovic, and I apologize to that couple, the Indiana Court of Appeals declined to recognize a Bosnian divorce decree that had been issued a few years earlier because the Bosnian divorce did not resolve division of their marital assets. Therefore, Indiana was free to divorce the parties if it had jurisdiction to do so, even though they were already divorced, because it did not recognize the Bosnian divorce decree as a matter of comity. In the case of Habibzai versus Jafarova, the Superior Court of Connecticut decided to recognize an Azerbaijani divorce. It could not recognize the divorce as a matter of comity because neither spouse was domiciled in Azerbaijan at the time it was filed. That's a requirement in Connecticut case law that they will recognize the foreign divorce decree, but one spouse has to be domiciled there. That is the nexus between spouse and jurisdiction in order to grant a divorce. The court in Connecticut, even though it couldn't recognize it as a matter of comity, did recognize it as a matter of practical recognition. Connecticut has this equitable concept to allow its courts to stop a party from challenging a divorce that might otherwise be legally deficient when the parties have been relying on that divorce. And that was the case here. One of the parties was remarried, they were filing individual taxes. It's now 9 years later when one of the parties decided to challenge the Azerbaijani divorce. So um, that was allowed to be recognized not under comity principles, but under practical recognition, which is specific in Connecticut. Some other states have that concept as well. So that's all from the United States. I'm going to take down my slideshow so that James can put up his and give the microphone over to him.
Thank you very much, Melissa. I can't believe it's been 7 years of us doing this together, which is crazy. Time flies, eh? Hopefully, I'm just saying, hopefully you will be able to see my screen here. Give me a shout if you can't see it. So, for those of you who haven't had the pleasure of meeting, my name is James. I'm a solicitor at the International Family Law Group in London, and we specialise in weird and wonderful international cases, be they children, divorce, or both, or somewhere in between. I wanted to take this opportunity to go through a few major issues that we are seeing, or we have seen over the last year. So that's the menu for today. I thought actually it's quite interesting, Melissa, that you brought up the Winchester case. I acted for the mother in that case, as well as that Jenkins, the Japanese Texas one as well. It does seem like this is quite a prevalent issue when you've got US servicemen and women who are stationed abroad and jurisdiction. For Miss Winchester in particular, it was really challenging because she had this English custody order that basically said, bring your kids back to England. She followed it. She landed at Heathrow Airport, and the border agency staff at the gate, when she arrived at Heathrow, said, "Sorry, you're not coming in. You haven't got a visa to enter. Your service status had been revoked." So she had to go back on the next flight to Indiana. So she's ping-ponging between these two countries, and ultimately the matter was settled by agreement. But you see that these international cases throw up so many challenging issues, not least when you've got US citizens, US servicemen stationed, be it in the UK, be it in Qatar, be they in Japan. So these are all issues we have to consider. Anyway, view from the UK, I wanted to give you a little bit of a menu. So we're going to talk a little bit about shared involvement, parental responsibility, DV, divorce tourism, and a few other bits and pieces. So we might as well kick off because I realise we've got a fair bit to cover in a short period of time. So the first issue I wanted to cover was that of shared involvement, and by which I mean this is a presumption we had in inverted commas, and you'll see why I say that in a second, in terms of both parents being involved in a child's life. So to start with, there was this presumption that was brought in 2014 and came into force 2 years later, introduced by our Children and Families Act, which said that the court has to consider and has to start from the position that a child's welfare is furthered by the involvement of both parents until the contrary is shown. Now, there's a lot to unpack in that. Child's welfare, furthering it, both parents, involvement being the key word. Now, an involvement doesn't necessarily mean that both parents have an equal share, 50-50 of involvement in that child's life. However, there was this general fear slash perception that this concept, this presumption was used in order to justify contact, quotes, at any cost. So children were being forced to spend time with parents, whether they didn't like it, or more polemically, if there were findings of domestic violence or serious allegations of domestic violence. It's attracted criticism all over the shop. And there was the suggestion that the courts were somehow predisposed to contact, but this review does dispel that notion completely. So there's a big long review of the family justice system, and the UK government repealed the presumption of parental involvement, which it was argued shifts a bit of a prioritization towards safety of a child over automatic parental contact. I don't think that this is the seismic change that that some campaigners have certainly put out there. I don't think it is as huge as it is, but quite frankly, if you've got findings of harm, then they're findings of harm. It's just a question of how to deal with it, not just this is a finding of harm and therefore this child must have contact with the other parent. It is something to be mindful of, and judges are becoming increasingly mindful of these issues when issues of internet contact in the international and in the domestic contact arises. So moving on to an issue of parental responsibility. Now, this is a very, very fun one indeed. So I represent the father in this case, which has now gone to the Court of Appeal. Now, in our jurisdiction, you have parental responsibility, parental rights, or right of custody, as it were, over your child if you are named as the father on their birth certificate. Not too complicated, right? And that's been the case for years and years and years. I know it's been mirrored in many other jurisdictions, potentially in yours. But what happens if you are named on the birth certificate and you later find out that you are not the biological father? What happens to the legal status of your parentage? Do you lose it immediately? Were you ever the father? Is it void or is it voidable? And this came to the fore in this case of KLVBA. So this father had a child with a mother. They were never married. The child is now 5 years old. The mother abducted the child to Indonesia, of all places. She returned voluntarily, and later the father started Children Act proceedings predicated on the basis of him having parental responsibility for the child. Now, he had PR because he was named on her birth certificate, but a later DNA test proved that he wasn't the biological father. Now, the question for the court, and this is at the High Court level, was did the father have parental responsibility? Was it void ab initio, or should the court void your parental rights automatically? Do you need to consider, for example, whether a child's best interests are served by an automatic, complete rupturing of parental responsibility? So you can imagine the practical arrangements for these sorts of cases. So let's say you've got a child who's called one man dad all their life, only to find out at, say, the age of 14, 15, 16, that this man has never been your father. So this is an interesting cross-section about whether you're a legal parent, a biological parent, a psychological parent, and you can see it spilling into, for example, custody cases or international cases where a father may not have had a right of custody at the time of the removal. You can see that argument coming a mile off. So the judge at High Court level, who was a judge called Deborah Powell, KC, she heard this case and she determined that the gentleman involved never had parental responsibility. But she was clearly so vexed by this issue that she, of her own notion, which is exceptionally rare in England, she granted permission to appeal to the Court of Appeal against her own judgment. So we had this 2-day trial. She gives us this big long judgment, and then she says, all right, you can go to the Court of Appeal and start all over again. This spiraled somewhat, and this appeal was conjoined to 4 other parental responsibility cases. One is a social services case, one is this case, another one is a slightly tangential case about parental rights. And the 4th one, it's the case where just under, watch this space, re A and B paternity identical twins. This is an absolutely fascinating case, which has grips the family law nerds of England. This is a mother who had separate, consensual sexual relations with 2 men. However, the 2 men are identical brothers. So she's not related to them, but she had sexual relations with both men and they are brothers. A child is born out of this relationship, and one of the fathers applies for a declaration of parentage to confirm his parental rights over the child in question. Now, the issue here is that they did DNA testing on both men, and both DNA tests came back saying they are both the fathers. Clearly, biologically, scientifically impossible. This was taken to some of the world-class geneticists at King's College London, the university here, that said it might be possible to establish which of the 2 men in question are the fathers, but you'd have to sequence the entire genome for this, and if you did so, it might establish parentage, and if it did, there'd probably be a 90-95% chance of that being correct. And that is, as a matter of our law, not a threshold high enough to be accepted as a matter of law in a declaration of parentage case. Another provider was asked, somebody called DNA Legal, and they said it would cost £90,000 to carry out paternity testing and take at least 3 months. Ultimately, it has not been possible to establish which of these 2 men is the father of the child in question. And the real question may be, will it ever be possible for this parentage to be ascertained, confirmed? This is something that troubled the Court of Appeal greatly. Now, all I can say is watch this space. This hearing took place over November, December time. It was a 3-day Court of Appeal hearing. We had interveners providing amicus briefs all over the shop. We have far too many lawyers involved in this case. But because there are so many lawyers, no matter what happens, either way, there's a chance this might go to the UK Supreme Court. So yeah, just keep an eye out for that one. It is absolutely fascinating, especially the paternity identical twins case. I understand that this happened in Brazil a few years ago. And I think the conclusion of the judge was flip a coin in ascertaining who is the parent. I don't know whether our Court of Appeal will be invited to do the same. Anyway, moving on to the next issue, one about domestic violence and abuse, but specifically first in the case of divorce and matrimonial proceedings. Now, you don't often hear of these issues being about these issues being brought to the fore in a financial case, but this matter is particularly relevant. This is a case of PN and SA. They were ultra high net worth individuals with marital assets in the region of about 460 to 540 million pounds. And when they separated, they had accrued wealth of 1.5 billion pounds. The father, very candidly in evidence, which I thought was very bold of him to admit, he says to the judge, the husband said in evidence, fairly it seemed to me, that the family has accumulated more money during their marriage than they could ever sensibly spend in a lifetime. So what is a court to do in these circumstances? Well, following their marriage in 2021, this very rich couple entered into a post-nuptial agreement to replicate the community of property regime that they had had in their home country. And basically, they wanted a 50-50 division of marital assets upon divorce. Then, a year later, following their separation, the husband and wife signed a settlement agreement, and it put in loads of really complicated structures about trusts, and the husband was trying to place his finances in trust to be very efficient tax-wise. He was going to charge fees. It was going to kick back. It was a tax lawyer's dream, but a poor family lawyer's nightmare. The wife, however, in this case, said that this second document that was signed, the settle agreement, was something that should not be upheld by the High Court. And her reasoning behind this was because she said that she had been coerced into signing this agreement. This all went to the High Court, and the judge, Mr. Justice Cobb, held that the first post-marital agreement was valid, fine, kosher, tick, great. The second one, the post-nuptial agreement, however, was not just a bit iffy, but not to be upheld. It was ruled to be invalid. It was said to be neither complete nor fair, and the court ruled that the husband had exerted a huge amount of pressure on the mother. He warned that she'd be stacking the shelves at the local supermarket and working the tills at Tesco, and built up what the judge said was a persistent level of psychological pressure on the wife. It's rare, at least in my view, to see in our jurisdiction family law, divorce cases and matrimonial cases having issues of coercive control and controlling behavior embedded so deeply and having such a radical outcome. So it is something certainly to keep an eye out in terms of family violence going forward. Another DV case here, and these are two cases that are going to our European Court of Human Rights later this year. And for those who know Dr. Marilyn Freeman, her organisation, the International, let me get the acronym right, International Centre for Family Law Practice and Procedure, are intervening in that case. So it's going to be a biggie. So these two cases involved the UK's respective laws on removing parental responsibility. I'm specifically using the word UK here because there are two cases. One is from the jurisdiction of England and Wales, and one is from the jurisdiction of Northern Ireland. And the two cases are united before the European Court of Human Rights. So, as a matter of English and Northern Irish law, parental responsibility is given automatically to married parents. You're married, you have your baby, you get parental responsibility. If you're not married, you can be named, and if you're named on the birth certificate, you will gain parental responsibility. As a quirk of English law, it is possible in very certain circumstances for a father's parental responsibility to be terminated. It's a power under the Children Act. It's very, very rarely seen. I know certain jurisdictions, they terminate parental responsibility. I don't want to say at a drop of a hat, but far more readily than we do. We have this notion in English law that it is very difficult, if not impossible, to terminate parental responsibility unless a child is being adopted or the child's welfare and the domestic violence involved is at such a high level to warrant that sort of restriction. We just don't do it. I know in other countries, I think if you spoke to our Polish colleagues, they might have a very different view on this, and maybe in your states as well. As a quirk of English law, you can only remove parental responsibility if the mother and father were unmarried. Is that, in and of itself, tantamount to a breach of your human rights, your constitutional rights? The level of domestic violence in particular is very, very high. I mean, there are other ways of doing this. Instead of terminating parental rights from somebody who is a baddie, a really bad guy, what you would do is you'd have orders that injunct the father from exercising parental rights on a daily basis. And that's sort of the side way round it. In these cases, which is we expect going to be quite a landmark case for parental rights and termination of the same. The question is this a breach of your right to respect for private and family life under Article 8? By virtue of the fact that the child and the parent involved has been unsuccessful or unable to apply for the revocation or the termination of parental rights. This I also think is interesting because, as I say, the English concept is very much of you will have parental rights and you'll have until the day that you die, as opposed to certain European states, and you will have judges from those European states hearing this case. As I say, watch this space. It's coming out later this year. We haven't got an indication as to whether this matter will be heard on paper or whether this matter will be heard in a hearing. It's quite rare as well for the United Kingdom to be the respondent to a case in the European Court of Human Rights in relation to family law. So it's one to get excited about for all nerdy international lawyers, as I say. Next, the trials and tribulations of the Potanin family. This is a tremendously wealthy family of Russian heritage with connections to England. So much of the husband of wealth was held by trusts and companies, and he's worth about 20 billion US dollars. He has been twice ranked as the richest person in Russia. And following extensive divorce proceedings in Russia, the wife reportedly received a grand total of around 1% of that wealth after a 31-year marriage. And there you'll see your friend and mine, Vladimir Putin. This is another Vladimir Potanin, who is the husband in this case. We have this process, and this is something that is vital for your clients, especially if they've got UK connections, under the MFPA 1984, which means that you can have a try at opening financial proceedings in the UK, even if your divorce and even if your financial arrangements have been settled in another country. It is quite a technical area. They're rare to see these applications. It's known as a Part 3 application. But this is coming from a background whereby the UK, or rather London, is seen in many ways as the divorce capital of the world. We have certain principles that would, to use a very English phrase, knock your socks off in terms of maintenance for life, spousal maintenance for life in certain circumstances, and a sharing of 50-50 in certain circumstances or in most circumstances as your starting point upon the dissolution of any marriage, and some rules about prenups that may or may not benefit your clients. So what do you need to do? Well, this case has been to the Court of Appeal. It's gone to the Supreme Court. It was remitted to the Court of Appeal this year. And that is a judgment that's referenced in September 2025. And that is how the Court of Appeal has construed what you need to do in order to bring a case under this legislation under Part 3 for basically having a second go at your divorce settlement. The threshold for this is higher than merely satisfying the court that a claim should not be totally without merit. It needs to be that you have a real prospect of success before you just throw in an application under Part 3. What was previously happening under our rules, which I think most lawyers would still steer well clear from, is that you would apply ex parte. You'd apply without telling the other side and say, please, judge, can I start this case? A judge would go, all right then. And then it would be incumbent on the respondent to say, hold on a minute, there's a reason why this shouldn't take place. It was all a bit on its head, and I don't really understand why it was drafted that way. The Supreme Court took quite a big issue with it, and the opening sentence in the opening paragraph of the judgment of the Supreme Court is Rule 1 for any judge dealing with a case is that before you go to make an order requested by one party, you must give the other party a chance to object. Yes, there are exceptions, particularly in children cases, but this is the starting point, so you can tell how that influenced the judgment going down. Basically, keep an eye on this. If your clients have got an English connection, if they can demonstrate an English connection in particular, it needs to be quite a substantial one. It doesn't have to be, I liked Harry Potter and I've been to London once. It has to be a real substantial connection to the United Kingdom in order to mount a Part 3 claim. Mrs. Potanina, she had an investor visa in the United Kingdom. She had been here for some time, and notwithstanding the length of her marriage to a wealthy Russian, she was able to bring proceedings in the UK. And that is still now kicking away before the High Court. So again, another one. Maybe this time next year, I'll be telling you about the latest installment of the Potanin saga, which I don't think has any prospect of concluding anytime soon. Again, just a quick one on matrimonial assets. This is the case of Standish that went to the Supreme Court. It also might be a lesson for your client in terms of knowing when to stop and when to settle for what you have. So this is a husband and wife who had a 15-year marriage, produced 2 children, and the husband was very, very wealthy indeed. At the outset of the marriage, his assets were about 57 million, and by separation, they had increased to 132 million. He had transferred 80 million to the wife's sole name as part of some clever tax planning scheme. And the intention on the time was for the wife to transfer the sum to an offshore trust for the benefit of children, but funnily enough, that never happened. The wife, at first instance in the High Court, she received a settlement of 5 million. The wife appealed, the husband cross-appealed, and the issue at the crux of the father's appeal was about what should go into the pot when dividing the assets and whether certain transfers should or should not be part of the matrimonial pot when you're dividing it. Oh, sorry. The wife had her award reduced from 45 million to 25 million. Oopsies. God knows whether the husband would have appealed of his own volition, but she was certainly the appellant in this case. She thereafter took it to the UK Supreme Court, and the Supreme Court unanimously dismissed the wife's appeal, ruling that non-matrimonial property should not be subject to the sharing principle, our principle of sharing assets. And the judge confirmed that matrimonialization, i.e., when you turn non-matrimonial assets into matrimonial assets, requires very clear evidence that the parties intended to treat the property as a shared resource. You'll see the cute white leopard there. That was referenced in the judgment in terms of this matrimonialization principle. It's quite an interesting creative judgment, but very rare. I don't know whether it's revolutionized how we see matrimonial property, but certainly a lesson, if not for anything else, as to when to know how good you've got it, rather than losing a good 20 million, but there we are. Next one, the thorny A word or PA word, this parental alienation word. This is something that has occupied the minds of many a judge across many a jurisdiction, and whether parental alienation exists, how you characterize it, who diagnoses it, what you should do with a quote diagnosis, who makes findings in relation to it, and it has caused very, very, very stark outcomes for families, for children, where parental alienation is used, levied, thrown around, and so on. So this is a case of OVC, which is heard by the High Court, where it concerns the use of an expert, and specifically a psychologist, and an unregulated psychologist at that, so somebody who was not regulated by the board of psychologists that we have in the UK. There was a lady called Melanie Gill who was appointed by the court previously and stated in her assessment that the children were suffering emotional and psychological harm as a result of the mother's parenting. And as a result, a very highly charged judge transferred custody or care of the children from the mother to the father at an interim hearing. This went on, it exacerbated, and the mother was left with a significantly constrained relationship with her children. This was the subject for yet a further round of litigation in the ONC case, where the court's view on parental alienation and some Family Justice Council guidance that came out in December 2024, which is important reading for English practitioners in this area. It sort of turned the whole concept on its head. The Family Justice Guidance reminded the practitioners and the judges in this area that any allegation of parental alienation is, well, that it is a pseudoscience as far as we're concerned in the UK on this point. I have to phrase it very carefully here. And furthermore, it is for a judge to identify what is known as alienating behaviours, potentially with the help of experts, used carefully, but with an eye to primarily the child's welfare. So because of all of that and the sea change in relation to parental alienation, the children's contact was severely limited, and then this matter was sort of overturned and placed on its head. There was a high level of media involvement. The Bureau of Investigative Journalism were involved in this case. It was quite a stark one, and the case has trundled on from there. I know that it is subject to further litigation in the High Courts at the moment. So yes, whilst you can use the phrase alienating behaviours, you've got to do so with great care and when you've got the evidence to back it up, which perhaps in the past certain judges in our jurisdiction were throwing the terms around far too easily. Now, for I think the final chapter, one of child dumping. And when I showed Melissa my presentation just before we started this afternoon, she saw that her eyes were widened by my phrasing, the use of child dumping. And I'm afraid that, well, I'm sorry for using it, but this is not my words. These are the words found in the Daily Mail, that erudite legal publication. But I wanted to use it because of the phrasing involved. So let me start with this case of Re M. I represented this 16-year-old young man. And this is an application which I think is relatively unique in our jurisdiction. I don't know in the US if you'd have the locus or the standing to do this sort of thing, but it's whereas a child or young person in and of their own right makes an application to the court as the applicant in wardship. So this was a child who was British but of Somali heritage. The mother and father was Somali. The mother was living in Somalia and the father was living in England. The child had been shuttling between the UK and Somalia, and ultimately the child was deceived into traveling to Somalia and stayed with his mother in Mogadishu. He told me in no uncertain terms about his life in Somalia, and this call came in when I was on vacation and I was by a pool, and I had this weird call come through from an international number from the side of the pool. And it was this young man who was telling me in no uncertain terms that he needed help in order to come back to the United Kingdom as he feared for his life in Somalia. This young lad had, and this judgment is really worth reading in full, I've got to say. It's one of the most fascinating cases I've ever seen. This young lad had found himself in a Reddit online YouTube rabbit hole and had decided to, following his lived experiences in Somalia, that he was going to renounce the religion of Islam. This apostasy, as it's known, is something that he was exploring in great detail on YouTube and in Reddit forums. And ultimately, he came to the conclusion that he no longer followed the teachings of Islam and he wished to renounce his religion at the age of 17, I believe he was at the time. That in and of itself carries a death sentence in Somalia with the state authorities, and more to the point, local militia, local gangs would, if they were to find out about it, well, it wouldn't end very pleasantly for the young man indeed. He started High Court proceedings in order to seek orders for the court's assistance to return him to Somalia, from Somalia to the UK. Whilst he was doing so, he claimed that and with some credibility here, as the judge found, he stated that he had been doxxed, i.e., somebody had hacked into his computer and was spreading information about him leaving the religion in Somalia. It was becoming increasingly pressing, and he was receiving messages, and these are recited in the judgment of Mr. Justice MacDonald, where he says, The messages he was receiving include, "It's just a few days until we find out where you are. Your name is his name. Beautiful patience. The promise of Allah is coming. We will not yet let you rest." He was sent something akin to a beheading video. He was being sent really nasty stuff by anonymous people online. On his behalf, the High Court made an order making him a ward of the High Court, allowing the British passport authorities to issue him with an emergency travel document, which we couriered to him in Somalia. And we thereafter arranged for a flight for him to leave Somalia, pursuant to a High Court order, and travel to the United Kingdom. And this is the most important part about this case, this all took place without the mother and father knowing that this litigation occurred. The judge held that if the mother and father were to have notice of the proceedings, they could pose serious risk to the life, well-being, and the welfare of this child in Somalia. It is extraordinary to see such huge steps being taken by a young person or a child without notice to their parents. I don't know if you guys would have had this sort of thing in your jurisdiction. It was exceptionally rare because of the content of what this young man was saying. The young man returned to the UK. He's now in foster care in the UK, provided by the local social services. And his parents were later served with the proceedings. They attended one hearing and then they dropped off the face of the earth. A really, really fascinating case, and it engaged Article 2 and 3 of the European Convention on Human Rights about the right not to be killed, not right not to be tortured, versus the Article 8 and the article of a right to family life and also your right to a fair trial. So yeah, if you've got a bit of spare time, I would encourage you to have a little read of that one. Some cases, however, are not as clear-cut as it was for the young man in Somalia. This is a case of Ries, and I represent this a 14-year-old British Ghanaian lad who lived with his family in London. So this is this young lad. He's around 14. He's acting up a little bit at home. He's getting in trouble with his school. He's getting suspended. He's not wearing his school uniform properly. He's hanging around with the wrong sort of guys. He's coming home with expensive clothing that looks a bit suspect. He's braiding his hair. He's going out all hours of the night. He's hanging around with the wrong sort of friends. His parents are becoming increasingly concerned about his behavior, the company keeps. In March 2024, he is told, "We are going to go and see your grandma, who's a little bit sick, in Ghana." He packs his bags, the family go over to Ghana, and you might be able to guess what's coming. He is told when he arrives in Ghana that his grandma's not sick, and in reality, his parents have taken the decision to place him in a local boarding school. They have done so without any prior notice. They've deceived him into traveling over there. They return to London alone, leaving him in the care of the boarding school in Ghana. This very, very resourceful young man starts making inquiries with the British High Commission, the British authorities in Ghana, in Accra. He reaches out to his school, he reaches out to the local authority, London Social Services, and to Children and Families Without Borders. Somehow he ends up with my phone number, and we start proceedings in London, in which I seek for an order that he has to come back to London. Now, the crux of this case is effectively these two parents, both of whom have parental responsibility for this young man. They have been exercising their parental rights, making a decision in order to, as they see it, safeguard their child and place him out of harm's way. This came before a judge, Mr. Justice Hayden, and the applicant in January 2025, and the application for his return was refused. The judge says it is in the generous ambit of parental decision taking. He refers to the NSPCC guidance, which is the Society for the Protection of Children, guidance on grooming and gangs, and there's a tick list, and he ticked, I think it was 19 of the 24 criteria that he was exposed to gang culture and that he was at risk of gang culture. I say that pausing for a second. If you look at the list of the criteria, they include things such as using social media, using slang words, going out late at night, arguing with your parents, that sort of thing. So I think there's not many children and young people who don't tick some of those. So take that with a pinch of salt. Anyway, this goes to the Court of Appeal, and the High Courts were, sorry, the Court of Appeal were of the view that all issues in relation to this family's options were not considered by the High Court, and the non-return order was overturned, and the matter was remitted to the High Court. The matter then came before Mrs. Justice Tice, who had to deal with this case, trying to determine, on the one hand, whether this child should be brought back to England in line with his wishes and feelings, which were very strongly held, and on the other hand, against his parents' wishes. Now, his parents did at one point say, well, if he is to return, we don't want him, so he'll have to go into foster care. Not a particularly attractive argument, but there we go. They also said, well, he is Ghanaian. This is our decision. We have decided to put him in out of harm's way in Ghana. It's quite interesting. When I raised that point with him, he said, James, he said this to me, James, you're as Ghanaian as I am. He did not feel Ghanaian. He didn't speak the local language Twi. He felt like a foreigner. He felt culturally displaced. He was an outsider. There is a point here. Who on earth is this kid? Who the hell does he think he is, quite frankly, to sue his parents? That was another argument. These are adult issues, and it is for the parents to decide what's best. Also, quite uniquely in this case, it was both parents acting together. It wasn't one parent who dumped the child in Ghana, to use the Daily Mail's words, and one parent who wanted the child back. It was mum and dad working together in unison to get this child out of harm's way and put it there. There were immense feelings of abandonment. We had a child psychiatrist. We had an independent social worker who provided views to the court about what should happen next. And ultimately, it was down to what is the least worst option, whether family members in Ghana, whether family members in England, could he stay with his mum and dad? Could he stay in foster care? If he goes into foster care, will he be placed at risk of the very things that his parents wanted it or were warned about? His mother gave very compelling evidence, full credit to her. She said, I don't want my son to be another black boy stabbed on the streets of London. And it was very, very telling. And that is something that stuck in the mind of the judges throughout the case, as well as all the social workers, all the professionals involved in this case. It was one as well that got quite a lot of media attention, for better or for worse. The media did tend to spin it as, is it better for this kid to be in Ghana? Or are children better off in Ghana, or are children better off in England? It was not that. It was what is best for this child and what realistic options are there. So it went before Mrs. Justice Tice late last year, and ultimately the judge, faced with all of these outcomes, made the decision that this young man was to return to London potentially after he finishes his GCSE exams in Ghana. So that is the age of 16. So he's got another year and a half, bless him, at least in Ghana. The judge also put forward a roadmap for him to come back to England after he turns 16, completes his exams there. And then, well, he's a 16-year-old young man, and we'll see where it goes from here. It was a very tricky, very finely balanced case. I don't envy her ladyship, Mrs. Justice Tice, for having to make that decision, or indeed Mrs. Justice Hayden, who had to make it the first time round. It's not a pleasant outcome for anyone in this family. Nobody has, quote, won this case, regardless of how you look at it. And it does take some tenacity to use, for want of a better word, for a young man to stand up and sue his parents in courts. It's not a question about whether life in Accra or life in London is better, but it really showcased a clash between what were some quite socially conservative views of quite a Christian, traditional West African family versus a young man in London who are finding their own feet and finding their own agency and fighting against their parents. And given in particular the UK's connections with former British Empire states such as Ghana, Nigeria, Kenya, India, Pakistan, this is something we see because we have populations of those countries in the UK with children. A lot of them are first generation immigrants, and this is something we're seeing really prevalently. our cases in this area have exploded. I've got one ongoing at the moment with Pakistan, one involving Zimbabwe. My colleague had another one involving Zimbabwe. There's one going on with Sierra Leone at the moment. We're seeing lots of these children and young people acting as protagonists in these stories, as applicants in their own right. I was going to make a reference to the UN Convention on the Rights of the Child, but I guess that's less relevant for you guys than it would be for certain others. But just to end on this note, you may have seen this case reported in the media. It was on the New York Times, it's on TikTok, it was on BBC, and it was on the Daily Mail, as I say. If you're looking for informed legal debate, I would not recommend the comment section of the Daily Mail website. That should not come as a surprise. A lot of quite interesting personal attacks about the lawyers who had dared bring this case on behalf of this young man. Um, but there we go. It has caused a huge amount of debate, especially for those who have uh, subcontinent heritage from West Africa or indeed from India, Pakistan, Bangladesh, those sorts of states. This is certainly not going to be the only child we try and get out of these countries, and it is potentially another step in now that a young person has phone, Reddit, internet, YouTube, Google, they can find a lawyer in a way that possibly wasn't available to them 20 years ago or 10 years ago. You might previously have had children who reach out to their schools in a new country or gone to the High Commission or found contact with the High Commission, and maybe it would have filtered its way to a lawyer. But now I can get a call tomorrow, or you can get a call tomorrow from a lawyer stuck in name a country, and you can bring an application to the High Court in England at least, and it broadens the playing field, as it were. It means that more people can make applications, more young people can make applications in their own right. And arguably, it's a better way of showcasing the wishes and feelings of children and young people in a way that sort of is beyond criticism. It's not got the veneer or the filter of a parent or a social worker or a judge. It is I am a client. My client is this young person, and this is the application they wish to make. I know Melissa made reference to judges meeting children and how that might be sort of uniformed across your jurisdictions. I wonder what the US system would do with child as applicant cases, but maybe the test case will be out there somewhere. So yeah, give me a ring if that does happen. I'd love to see how other jurisdictions deal with young people making applications in this manner.
Just not
I
while you're
think
on the beach.
just not whilst I'm on the beach. Well, funnily enough, I was on the beach with my 3-year-old nephew squirting me with a water pistol whilst taking these calls from children being stuck in Africa. Anyway, I think that is everything from me. I realise it's been a bit of a whistle-stop tour, and there's a few minutes left. It's been quite an intense blurring of information out. But if you have any questions about this, any other case, anything else from the UK perspective, I'm always happy to speak, phone, email, video. You'll have my contact details. And yeah, thank you to the State Bar Association and to Melissa for organising all of this, and thank you all guys for listening to me ramble on. So I
Hopefully,
think
we'll
that's
have
it.
an eighth version of this in January of next year.
Hope so. Hope so. Yeah.
So if you've registered for this, even if you haven't stayed logged in the whole time, the New York State Bar will send out an email. It'll have our slides and it'll have a recording of the webinar. So we're really grateful that you're here. And if you had to step out during the program, you'll still get to see all of it. So thank you so much. Happy New Year to everyone, and look forward to seeing you all around.
Thank you so much,
Thank you, everyone.
Melissa. Thank you also, James. And thank you to all our attendees for joining. And yes, we'll be sending the materials shortly after the program and once the recording is available. Thanks, everyone.